morning. The Senate Judiciary Committee will come to order. Today is February 10, 2023, and I think by my count we have a quorum present. I will state it declaratively. We do have a quorum present, for the record. Just a brief announcement before we start. We have been having a number of hearings on Fridays because we have a whole lot of bills coming to this committee that we need to fit in, but I think you all be pleased to know we are not going to meet next Friday. Except for Senator Limmer, who will come here to the Capitol just to tell people that he was here doing his work. All right. So we're going to start with Senate File 293. Senator Oumou Verbeten, why don't you go ahead and explain your bill, and you can have your testifiers come forward when you're ready as well.
Thank you, Mr. Chair and members of the committee. Today I'm presenting Senate File 293, which bans the box on applications for state boards and commissions. Ban the box legislation prevents employers, and in this case, appointing authorities from asking applicants about their criminal records and history until they have been selected for an interview or otherwise selected as a final candidate for a position. Everyone should have the chance to show their qualifications rather than be eliminated from consideration on page 1, day 1. This bill brings the executive branch up to speed with public employers and private industries across Minnesota and the country who have banned the box. And we are a leader in this area as a state. In 2009, Minnesota became the second state in the nation to ban the box for public employees. In 2013, we banned the box for private employers. Banning the box gives folks an opportunity to sit in interviews and really connect with employers on a human level before disclosing their criminal history. And they can explain those mistakes of their past, and employers can judge if that is relevant to the position. Employers can and still do run criminal background checks later on in the process, but it's important to note that sometimes these past convictions are not even related to jobs that folks are applying for, and in this case, those boards or commissions. We're missing out on great applicants when people decide to not even apply. You know, they have this fear that their application will just be thrown out, or they won't have that opportunity to share their qualifications and, again, explain any of those mistakes from the past. And we don't want folks to self-select. We want to cast a really wide net with larger, more qualified applicant pools. And also for decades, this stigma has really weighed heaviest on people of color, and it's hindered their ability to seek employment or opportunities to serve on these boards and commissions. So this bill also includes some technical fixes to our application process, and our testifiers will go into more detail on that. But just to conclude, it's really a loophole that we need to fix. We want a full statewide policy on banning the box, including on our applications for boards and commissions. And with that, do you want me to move my author's amendment first, Mr. Chair?
Yes, Senator Oumou Verbeten has an author's amendment. The A6 members, it's in your packet. It's a delete everything that puts the bill in the shape that the author would like it to be in. So Senator Verbeten moves adoption of the A6. All those in favor, say aye. Opposed? Motion prevails. The amendment's adopted. Senator Verbeten, I'm going to note that there are really two components to the bill now. There's the ban the box component of it, and there's some other process-oriented matters relating to clarifying definitions, vacancies, that kind of thing. This bill will be going to state government after it's done here, which will have is primary focus on those additional pieces, but because this is the Committee of Primary Jurisdiction, we'll get a review of those components as well. So we want to respect the time of our Secretary of State, who is here in support of this bill. So why don't we ask Secretary of State Simon to come forward at this time. Secretary Simon, go ahead and introduce yourself and make your remarks for the record, please.
Thank you, Mr. Chair and members. It's my pleasure to be here. Steve Simon, Minnesota Secretary of State. It's a pleasure to testify on this bill. Minnesota's open appointments process for boards and commissions was established almost 45 years ago, with our office responsible for administering the application process. And sometimes there's some understandable confusion in the public. We don't make the appointments, so we don't get to appoint who's on the boards, but we do run, for the benefit of the governor's office, that process. And that's been the case, as I said, for almost 45 years. This was originally conceived as a paper-based process. And only relatively recently, around 2016 or so, did the application and appointment process become primarily electronic. There are now over 250 state boards, commissions, committees, and the like. That's a lot fewer than there were when this design was originally conceived almost 45 years ago. This bill is the product of a lot of work between, obviously, the authors, the governor's office, and our office. And it allows for better tracking of the numerous and constant vacancies while facilitating the ability of all Minnesotans to apply and be considered for appointed positions on multi-member bodies. The bill clarifies appointment processes, the selection of members by non-governmental organizations. It addresses resignations, makes the application form consistent with Ban the Box. And to that extent, we see this as unfinished business related to the legislature's own quite clear and loud voice as far away as a decade ago on Ban the Box. It changes timelines to reflect web-based application and appointment timelines that reflect, modern life, automation. It makes clear that a person may hold only one membership position on a board, and it eliminates confusion between the governor's office and commissioners about which office has the authority to proceed and when in the appointment or vacancy filling process. So each of these provisions will help integrate the governor's office and the state departments in which most boards and commissions are administratively housed into the overall open appointment system facilitated by the Office of Secretary of State. I know, Mr. Chair, that's getting into some of the details that aren't necessarily the purview of this committee, but I thought people would want just a broad brushstroke view. I know that the name of the game in this committee is mostly, perhaps exclusively, Ban the Box, and I'm proud, as I was a decade ago, to support that. And this is just consistent with what we already do in the private sector, what we already do otherwise in the public sector as to the state of Minnesota. This is closing a loophole and providing more promise for more people to more fully participate in our public life. It's my pleasure to be here. Thank you, Mr. Chair and members.
Thank you, Secretary Simon. We also have Charles Cox, a Special Assistant to the Secretary of State. Do you have anything to add, Mr. Cox?
Yes, Mr. Chair, thank you.
Go ahead and state your name then.
My name is Charles Cox with the Office of the Secretary of State. This bill amends the existing laws on open appointments to boards and commissions, specifically to Minnesota statutes 15.0597, 351.01, and 364.021. As the Secretary said, this bill is a joint product between our office and the governor's office, and it is significantly technical fixes in order to improve the process, make sure our offices can work easier together and catch us up with the electronic age. So real quick, and like the Secretary also said, some of these are not the main purview of your committee, but I wanted to give a few details and a little bit more emphasis on the Ban the Box. The first four sections of the bill all amend Minnesota statute section 15.0597. Subdivision 1 clarifies how private interest groups make direct appointments to the boards and commissions, and clarify when legislative appointments do not actually need to go through the open appointment process. And it further clarifies who is an appointing authority and how they actually make that appointment. In section 2 of this bill, it provides that notice of vacancy may be made by posting the vacancy on our modernized open appointments website, which is configured in order to allow interaction between our office and the boards and commission staff directly. The section also clarifies that when a seat is to be appointed by the governor's office must be notified before we can post that vacancy onto our website. And that when the vacancy is caused by resignation of a member originally appointed by the governor, that resignation must be first received by the governor before the vacancy takes effect. That just fixes a small issue where the governor's office was sometimes becoming aware that they even had a vacancy on a board and commission by it popping up on our website, because board staff would communicate directly with us, despite the governor being the appointing authority. Section 3 amends subdivision 5. It deletes the question on the open appointment application form from asking whether or not an applicant has been convicted of a felony. This makes it consistent with other private and public employment law in the state of Minnesota. And it further removes a notification requirement when no applicants have been received during the mandated 21-day application period. That provision is now redundant because with the online system, everyone who's involved in this is seeing the applications and whether or not they're coming in real time. Section 4 amends subdivision 6, and it reduces the waiting period prior to making an appointment to 5 days after that aforementioned 21-day waiting period. It is no longer necessary to have that long of a time prior to appointment since, again, this entire process has been automated. That will help the governor's office fill slots on boards and commissions much quicker. Section 5 amends Minnesota statute section 351.01, and it clarifies that the case of a position that is appointed by the governor, any resignation must be received by the governor in order to be effective, not merely the chair of the multi-member agency. And finally, section 6, this amends Minnesota statute section 364.021. This is the section that currently bans the box in public and private employment across the state, and now it specifies that that provision also includes boards and commissions while still allowing for background checks later in the process. Thank you, Mr. Chair.
Thank you. While we have these two testifiers in front of us, any questions from members of the committee? All right. Thank you, both of you, for your testimony.
Thank you, Mr. Chair and members.
We also have Prince Corbett, who had signed up to testify. We believe that might have been either in person or online. Do we have any indication Mr. Corbett is here? Okay, so the only other thing I'm going to ask, I noticed that Human Rights Commissioner Lucero is present. Did you wish to testify in connection with this bill, Commissioner, or are you here just to observe?
Just to observe and answer any questions if there were any, but they've done a great job.
All right, thank you. All right, are there any questions or discussion from members of the committee? I'm not seeing any. Senator Cruin.
Thank you, Mr. Chair. I'm just trying to read all this on the spot. Is it normal practice to get an amendment that is quite a bit more significant? It's almost like an entirely new bill that I'm reading for the first time as I arrive here at committee. I'm just wondering when this was prepared, if this could have been emailed to us so we could have been more prepared to discuss it.
Senator Cruin, it looks like it was printed at 8:18 last night. But we'll just note most of the amendment here is state government committee related issues, and it's going there for them to consider all of that. The parts most relevant or most directly for us, there's one line on page 3, that's line 3.12. And then the new paragraph on page 7, starting at line 5.9. Section 6 starts on page 4, at line 4.27, which reproduces existing statute. And then in the middle of page 5 is the new paragraph, which essentially mimics the language found in paragraph A of chapter 364.021, but then includes language relating to boards, commissions, agencies as the covered bodies. So that's really the language that's brought this bill to the Judiciary Committee. So you've got 7 lines in the bill. Senator Cruin.
Thank you, Mr. Chair. And just skimming through this for the first time, I don't see anything that would give rise for me to ask a substantive question. But I guess my hope is that this doesn't become a practice, because it's not good for this committee to be looking at bills for the first time when you sit down. And this is essentially, as I see it, a new bill. And perhaps if this had been the bill, it wouldn't have gone to Judiciary first. It probably would have gone to state government, I imagine, as its first stop. I don't know that. I'm new here and I'm trying to figure out all the jurisdictional things, but I guess it's concerning to me that I sit down to a committee and I'm essentially looking at a new bill for the first time. And I guess that's just my comment. But as we walk through it here, I don't see anything of substance that I have any questions about. Thank you.
Thank you, Senator Kroon. We'll keep that in mind when amendments come up on other bills along the legislative process to see how much there's content there that has never been seen by any members of the committee before the amendment's introduced. By the way, this was introduced as a ban the box bill. That's why it came here, and I think what happened is the Secretary of State's office is taking advantage of a bill in the process already to clean up some language that's needed to be cleaned up. So any other questions or comments from members of the committee? Not seeing any. Senator Oumou Verbeten, care to make your motion?
Yes, Mr. Chair. I move that Senate File 293 as amended be recommended to pass and referred to the State and Local Government Committee.
Any further discussion? Senator Oumou Verbeten moves that Senate File 293 as amended be recommended to pass and be re-referred to the State and Local Government Committee. All those in favor say aye. Aye. Opposed? Motion prevails. Thank you, Senator. Senate File 61, Senator Kunesh, come on forward. Senator Kunesh, welcome to the committee. This is a Fair Labor Standards bill. We only have jurisdiction over portions of the bill. If you could give us an outline of the basic framework of the bill, and then I can ask council to review the portions that are specifically within this committee's jurisdiction that we'll be addressing.
Thank you, Mr. Chair. That's just fine. So members, in front of you, you have Senate File 61, which is a fair labor standard for agriculture and food process workers. The gist of it is that it amends 3 areas of worker protection laws: the Packing House Worker Bill of Rights, migrant labor laws, and recruitment in food processing and employment protections. It's important to know that many of these, or all of these, have not been updated. Some have not been updated at all. And that means that the protections to our agriculture and food processing workers have not been addressed for some time. The migrant labor law was enacted in 1981, and many of its provisions have never been updated. The most recent update was to the recruitment food processing. That was enacted in 1995. That has never been updated. And the Packing House Worker Bill of Rights law has never been updated, and that again was enacted in 2007. So what this bill does is it sort of updates everything and brings into compliance the fair labor standards for non-English speakers, mostly. If you look through it, there's a definition that basically includes poultry processing in the definition of employer for purposes of the Packing House Worker Bill of Rights statute. It ensures that there is information in the language of the migrant worker or the employee so that they understand their rights. It makes sure that the workers' compensation carrier and their compensation coverage is provided by the employer at the start of the employment in addition to existing information. It adds a new subdivision allowing an employee to bring a cause of action for an injury caused by a violation of the Packing House Workers Bill of Rights, and then it specifies damage amount, including costs and reasonable attorney fees. It also adds a subdivision that specifies that the Commissioner of Labor and Industry does not fine an employer not less than $400 or more than $1,000 for each violation, and that specifies that the fine to be paid to the employee aggrieved by the violation. It requires wages or commissions for migrant workers to be paid within 3 days instead of within 5 days, as it sits right now after that worker quits or resigns. And then it goes on to do a number of other definitions, talks about recruiting, civil action, increases the award amount allowed for damages in civil actions brought under these sections. It does increase fines for violations of the food processing, employment, recruitment statutory requirements, and requires that fine to be paid to the employee. It specifies any recruiting disclosure forms by a DLI be provided in additional language upon request, in addition to being provided in English or Spanish. And then it goes on to clarify a number of things, such as the biweekly 70-hour pay guarantee that would be computed by using the highest of the federal, state, or local minimum age, or an hourly wage rate indicated in the written employment statement, and it increases the amount to the amount paid to the migrant worker per day when work is not available under certain conditions. It clarifies record-keeping requirements, increases penalties, amounts for violations of migrant worker protection laws, and it allows the Commissioner of Labor and Industry to assess penalties and provide the penalty to the migrant worker aggrieved by the employer's non-compliance. And so, in essence, this bill updates and enforces some basic human rights of those that do the work that many other would not choose to do.
Thank you, Senator Kunesh. I forgot to note, just procedurally here today before we started, that the committee will take a break between 11:30 and 12:30. The Rules Committee is meeting, and we have at least one member here that's also on rules. That'll give the rest of us a chance to eat lunch, and it'll keep Senator Limmer from eating lunch, which might not be to our advantage in the afternoon, but it's all we can deal with. All right, I'm going to ask council now to just review specifically the provisions of this bill that are within this committee's jurisdiction for consideration.
Mr. Chair and members, Senator Kunesh provided a description of those provisions, so I'll just note the section number and the page number and can answer any specific questions as they come up. So section 1 begins on page 1. On page 3, sections 4 and 5. On page 5, sections 9 and 10. On page 8, section 19, and page 9, section 20.
Thank you, Ms. Primo. We have a couple of people who signed up to testify. We'll invite Bernie Hess and Jessica Groves to come forward to the testifier table, please. Welcome to the Judiciary Committee. Mr. Hess, if you could go ahead and state your name and give us your testimony.
Thank you, Chair Latz. Bernie Hess, I'm with the United Food and Commercial Workers Union, Local 1189. We represent workers in meat processing, food processing, retail, long-term care. We have a medical cannabis division now, and we have some light manufacturing. Thank you for hearing this bill. Committee members, we stand in support. I want to thank the Senator for bringing this forward. Meatpacking has changed dramatically in the last 30 years from when I was a young man on how plants were run. There's been a lot of compression in the industry, so we have a lot of big packers now that are in the game. We have many folks that work in plants that are the newly arrived. We have one plant where we have over 30 different languages spoken. So there are many new faces to packing, but in a sense, it's the same as many years ago when people would come to South St. Paul and work in the plants. Workers are often faced with a number of challenges. There's pathogens. We had the whole COVID situation, which people died in. Automation is incredible now in plants. So many things have been sped up. You can have to be very alert and trained in. Food safety equals worker safety. So if the workers are safe, you're going to have a very good process in regards to food safety. We have an issue with folks coming in and not really knowing how the pay situation is. And a lot of folks are initially brought into plants through temp agencies. And often they don't know, like if they're given a debit card to pull their payout, that how much they're charged every time they do a transaction. That's been an issue. Workers need to know their rights. It was very disappointing during the COVID crisis that so many workers that got ill were denied workers' comp because there was no presumptive thing in regards to how they contracted it. They also need know their rights under unemployment insurance and OSHA, and also what things are available if a plant, for example, goes down, where can they seek aid and assistance. And a lot of folks are new and are very cautious about approaching government agencies for help at times. And I just think back to several years ago, we had a plant in Buffalo Lake that shut. It was a beef slaughter operation, a kosher kill. It shut down, and folks didn't even stick around to hear about what was available because they didn't really feel comfortable approaching for unemployment insurance. And the impacts when plants go down, I'll give you an example in Buffalo Lake, they lost 80 students in that school district. It's not a huge school district, so there was a huge financial impact to that. We just want workers to go to work and come home in one piece. And in any given day in a plant, you might look at getting cut. There's been amputations when they don't lock out machines right. There's slips, trips, and falls. You can lose your hearing. There's scalds and burns, repetitive motion syndrome, shocks, because a lot of equipment now is electric. There's also exposure to a lot of different chemicals, not only ammonia with refrigerants, but also if you're involved in wrapping product, some of the things that are given off from that. So we support this bill. We'd ask your support, and I stand for any questions.
Thank you, Mr. Hess. Ms. Gross?
Chair and members of the committee, my name is Jessica Gross, and I am the Director of the Labor Standards and Apprenticeship Division at Minnesota Department of Labor and Industry. Thank you for the opportunity to testify in support of Senate File 61. To provide a bit of background, this legislation reflects one of the recommendations made by the Agricultural Worker Wellness Committee to the governor on December 1st, 2021. The committee was established via Executive Order 2114 and is comprised of local and regional representatives, worker representatives, community representatives, state agency representatives, and employer representatives. I am part of the state agency support staff team for the committee and represent DLI on the committee. The recommendation related to this legislation was approved unanimously by the committee members who were present for the November 22nd, 2021 committee meeting. This legislation would update penalties, damages, or fines available under 3 laws, those 3 laws being the migrant labor law, the recruitment and food processing law, and the packing house worker bill of rights. As mentioned earlier, these 3 laws were enacted years ago, and the legislation would update the penalties, damages, or fines to reflect today's dollars. Additionally, it would also expand the enforcement mechanisms available to address and resolve violations of these worker protection laws. Specifically, in relation to the migrant labor law, this bill would provide DLI with enforcement authority so that it can issue compliance orders and penalties for violations of the law, and it adjusts for inflation the penalties currently available to plaintiffs under this law. In relation to the recruitment and food processing employment law, the bill adjusts for inflation the damages available to plaintiffs under this law, and adjusts for inflation the fines available to DLI for violations of the law. In relation to the Packing House Worker Bill of Rights, it provides for a private right of action as well as authority for DLI to issue fines to address violations of the law. Additionally, Senate File 61 would provide penalties or fines that are assessed by DLI to the worker aggrieved. Thank you, Chair and Committee, for your time and consideration of this legislation.
Thank you, Ms. Gross. Are there any questions from members of the committee for either of the testifiers? Senator Limmer.
Thank you, Mr. Chairman. I'll make an admission that I don't know much about meat packing, nor do I know anything about the labor agreements between employers and employees. I see that there's a number of fines that are increased in your bill, and I was wondering, when was the last time these fines were adjusted?
Ms. Gross.
So I'll start first with the recruitment and food processing employment law. That was enacted in 1995. There have been no updates or amendments to that law. The Packing House Worker Bill of Rights was enacted in 2007. There have been no updates to that law either. The third law, the migrant labor law, was enacted in 1981. It has had one update, that was in 2005, in which 2 of the penalties available under that law were updated. The other penalties were not updated.
And Mr. Chairman,
Senator Limmer.
thank you for that. The Bill of Rights, the one that was you mentioned in 2003, did that include penalties that were specified in that?
Ms. Gross.
Thank you for your question. The Packing House Worker Bill of Rights currently does not have an enforcement mechanism, so it currently does not have finer penalties under that law.
Okay. Mr. Chairman,
Senator Limmer.
that's the first thing I look at when I look at any kind of fine or cost, even the cost of licenses that many professions have. I always ask the question, well, how long has it been? And oftentimes, time alone justifies a higher penalty due to inflation. I see that some of these fines can go 300–400% higher, and that always is a question of whether or not that's justified in comparison to the original number. Having said that, I see that the witnesses are all from the employee side of the ledger, but what does the employers have to say about these bills? Have we gotten any letters? I see that they're not on our witness list or our testifier list. So can you reveal to me if they've been informed about this bill, and did they seek an opportunity to testify today? It is, after all, affecting them.
Senator Limmer?
Senator Kunesh.
Thank you. I have not had any correspondence or any phone calls, any emails from them. This is the second hearing I've had, so they have had ample opportunity to speak to this issue. There's no testifiers here, so I wouldn't want to presume to speak for them, but perhaps their silence speaks volumes that you're looking for.
Mr. Chair, I don't know if I'd want to go that far, but I will note that your bill was introduced January 9th, and now we're getting into the middle of February. And so it's always good to hear from the other side, but it's unfortunate that they did not either they did not follow this bill or they have no opinion on it, as technically it's the only thing I can conclude right now. If they are listening somewhere on some something I would urge them to call their legislators, call me, call members of our committee before it goes, or before it progresses to the floor. We'd like to have their opinion on it. Thank you.
Any further questions or discussion for these testifiers? Senator Howe is online. Senator Howe.
Thank you, Mr. Chair. And I've got a couple of questions just to clarify my own, just to get my head wrapped around this, because I've got a lot of not only poultry packing in my district, but I also have a lot of farmers who hire migrant workers. So I've got a great interest here. In Packers House Workers Bill of Rights, we're adding poultry processing, and I guess I got a question. Why wasn't that included before? I guess my question goes is that I would have to believe that it was always considered that. I mean, so I guess we're adding it now, and I just want to know why it wasn't included in the original document. If they can give us some of that history.
Mr. Chair, Senator Howe, back then we were primarily focused on swine and beef. Poultry, the whole industry of poultry has really taken off in the last 10 years, 15 years. Also, the rate of automation has changed dramatically. There's more automation now in poultry than there was 15 years ago. And it is a protein, so we decided to have beef, swine, and poultry in the bill.
Senator Howe.
Well, Mr. Chair, if I can.
Yeah, Senator Howe.
Hey, so is it my understanding then, if now we're adding just poultry, does that mean fish processing plants aren't included in packing house rules yet either?
Senator Kunesh, if you know.
I would say no, they are not included in this now. Perhaps that's a consideration down the road, but for this bill and this specific bill, they have not been included.
Senator Howe.
Well, thank you, Mr. Chair and Senator Kunesh. I guess I just look at this and I'm trying to figure out, is it only when we add automation that we add the workers to the packing house deal? I would have thought that the more manual it is, the more stressful it is for these workers, and the more physical labor they have, the more work with actual knives than the automation would have actually made it riskier for packing house workers and not less. So I got the question as to why the more automation is there more regulation? Can somebody lead me out of ignorance out of that?
Mr. Hess will try.
Mr. Chair, Senator Howe, very good question. Automation's more dangerous, and I'll tell you why. You've got, when you go into like a beef slaughter, you've got head splitters, you've got saws. In the old days, some of the guys I worked with would swing a sledge in the knock box to stun the, now you're using a gun with a bolt. So you can either get, you can either put the bolt through your leg, which I've seen when the cattle gets agitated. I don't know how graphic you guys want to get, or members want to get, or the animal, besides being restless, will fall. We've had bulls fall on workers, all sorts of things. And because the pace is really increased, think about it. Down at Hormel's, they're doing 1,100 hogs an hour. This is not your father's packing house. These are factories that move very fast. And when things move fast, if you're not properly trained, people get hurt. So there's many more tools as opposed to like taking off the tip of all the old meat cutters I worked with, most of them were missing the tips of their thumbs. Now you can take off hands, you can take off a leg, there's all sorts of stuff. So I would argue it's more dangerous now. We have younger workers who often don't have the experience that older workers gain or have. So
Right.
Senator Howe.
Mr. Chair. Thank you. No, that's great information. My next concern here is, you know, we're changing when they have to be paid rather down to 3 days rather than 5. Running a business myself, I can see where the 5 days kind of works, but what happens when someone just doesn't show up for work, which means they quit and they ghost you, they don't give you notice? I would say, I'm just thinking, I'm trying to figure out why we're shifting 2 days earlier. I think that 5 days, you know, if they're gone 2 days and they didn't give you notice, is there language where they give you notice, then you get the 3 days, or if they don't give you notice, you get 5 days, or exactly how does this work?
Mr. Hess.
Mr. Chair, Senator Howe, if you note, first of all, the workforce is very fluid. They move around a lot. Often they follow plants when they're up and down. They move. Also, I think under state law right now, if you get discharged from a job, they have to pay within 24 hours. And because of the migratory nature sometimes of meat packing, it would really help out workers when they got to move to another location.
Mr. Chair.
Senator Howe.
The other concern I have with the migrant worker piece is that it looks like this is going to take effect 1 August. And in some of my area where they're starting harvest then, that's a little bit, we're not giving them a lot of time to understand this law and make the implications and the changes and actually even get notice of this change. So I would offer the A4 amendment and what this does is just back it off until January 1. So they've got more time to get the things in place and understand how this is going to affect their operation. So it would just it just backs it off a few months so they can, when they don't have all the operations going on, especially in the farmers end of the deal, so they have a better concept and be more compliant with the updated regulations that we're asking. And otherwise, it's just a change of date.
So Senator Howe, the A4 amendment has been distributed by staff to the members and to the chief author. I've got a question for you about it. It looks like it's amending, is it all of the effective dates in the bill, Senator Howe? Is that what your amendment is doing? I mean, we're just seeing it this moment for the first time, so I have to ask for a little clarity.
Yes.
So there are much
because
of
Mr. Chair, I do
Howe.
believe that having this effective August 1 really puts a lot of these employers, especially the employers of migrant workers, in a tough spot with trying to understand this and implement all these provisions. So it just relates not to everyone, just to the migrant worker laws that is effective, not everything in the bill, just the ones that apply to migrant workers.
So, Senator Howe, what I'm trying to discern in part, thank you for that clarification, is which of these apply to the portions of the bill that are primarily within our jurisdiction, which is the civil actions, the fines, the remedies, and which of these amendments really relate to the Labor Committee's portions of the bill where this bill has already been heard. So I'm trying to, I'm having difficulty understanding how at least the portions relating to this committee's jurisdiction would be difficult for employers to accommodate within the time frame already established in the bill.
Well,
I guess we'll ask
I have,
Chief Author,
Mr.
what you
Chair,
think.
if I may, I've got a lot of farmers that run milking operations, custom combining operations. So you're asking these folks that hire these migrant workers to, in some of their busiest time frame, they're putting in the crops, and then a few months later they're taking out the crops when this actually starts to apply, and we're not giving them a whole lot of opportunity to read and understand and figure out exactly how they're going to change the way they do business. In fact, you're in parts of this, it expands it to apply to a wide breadth of folks. So I'm just thinking that in order to give folks to actually understand it and comply with it, we need to give them a little bit of time in the downtime of their season to actually be able to comply and not get themselves in trouble with just complying with the way it was before. So I just don't want to rush this to implementation when they don't have a good understanding of how it affects them.
So why don't we get some feedback from the chief author or from Dolly if you have input on what Senator Howe had to say. Ms. Gross.
Thank you. I just wanted to note the fiscal note that we recognize that it will be important to provide outreach and education on these changes. So just wanted to point to our fiscal note that does estimate for fiscal year 2024 $50,000 for one-time for outreach and education efforts, develop trainings and presentations for employees, employers, and community organizations to make sure that everyone is well apprised of these changes.
For members,
Mr. Chair?
Senator Howe, hold on a moment. For members, let me just point out to you on the A4 amendment, the specific provisions that affect the portions of the bill within the Judiciary Committee's jurisdiction are lines 1.2 to 1.4, which is one effective date on page 2, and one effective date at lines 1.19 to 20, which is on page 9 of the bill. So those two effective dates are the only ones within this committee's jurisdiction for impact. Senator Kunesh, you want to respond to the amendment, and then Senator Kroon has a comment or question as well.
Thank you, Mr. Chair. With all due respect, I don't think I will accept this amendment. I haven't spoken with you about this. You haven't shared with me your thoughts around this. It looks to me like with the passage of this bill, there would be ample time for if the meat packers or the producers know this is coming. They have ample time. I'm sure they have plenty of employees and staff members that recognize the importance of getting this information out. So, Mr. Chair, I will respectfully not accept this amendment.
Well, Senator Kunesh has indicated this is not a friendly amendment from her perspective. Senator Howe, response, and then
Mr.
Senator
Chair
Kroon has a
and
comment.
Senator Kunesh, I've got employers, farmers that have 1 and 2 migrant workers where this has never applied to them before. And they don't have staffs. They have their wives and their brothers that operate with them, and this is all going to apply to them. And they've got to figure out how this applies and how they have to meet these requirements. And it's great that they're going to provide in 2024 all this great information and outreach, but that doesn't help them from August 1, 2023 until January 1, 2024, when you don't have that outreach and that information going to the farmers that are actually going to have to comply. So I asked, I apologize that I didn't get to you ahead of time, but I just got home last night. I reached out to my local farmers to see how this would affect them. And they have concerns. They don't mind doing it, but this has never applied to them. They've never had to respond to this type of regulation. So I think it only is fair to give them the time to actually wrap their arms around the regulations.
So Senator Howe, I'm going to note that the A4 amendment, according to the piece of paper in front of me, was printed at 3:17 yesterday afternoon. So the amendment's clearly been in the works for a little bit more than just this morning. And this is the kind of thing that would have been helpful for the chief author to be aware of ahead of time. I'm also concerned because frankly, we're starting to see a pattern here, Senator Howe, in which you're offering amendments to bills in areas that are completely outside of the Judiciary Committee's jurisdiction and asking us to consider these. And this bill has been around since its introduction January 9th. So I know things are moving kind of quickly around here, but I'm going to ask members, if you have proposed changes to bills, and please take a look at what's on the introductions lists as they're coming out, and do some due diligence before we get to the committee. And then even, you know, sometimes we have amendments in our packets, which means members and the chief author have had an opportunity to see them before they're sprung upon us in a comment from the senator as a surprise. I'm going to encourage members, just as a matter of process and practice here, if you've got an amendment and you want a good, sincere conversation about maybe adding it to the bill, it would be to your advantage to make it known to the committee and to the chief author before we're sitting at the table with the bill in front of us. I know that's not always possible and it's not always desirable, but I think it'd be helpful for the process to be effective here. Senator Kuhn wanted to make a comment about the amendment. Senator Howe?
You know, I haven't had much of an opportunity to be home. So I've been, and you know, this thing went to labor first. I didn't know what sections of this bill applied. I didn't have that knowledge of when this was that this was even, when it was introduced, that it was even coming to our jurisdiction. So, this was printed ahead of time, but I got out of there early yesterday to go home so I could get to my district to talk to my folks. You know, they're busy people just like I am, and we're not always being able to connect the way we used to, and especially when they're dairy farmers. I will, and I do look at the bill introductions, and I do circle those that I think that are coming to our jurisdiction. I'll try to be more effective to reaching out to authors, but with the pace that we're currently on, you can look at my schedule, Mr. Chair. I don't have a lot of spare time. Thank you, Mr. Chair.
Senator Howe, I think we can all identify with that concern here. Senator Kroon.
Thank you, Mr. Chair. 2 points on this latest issue. And this isn't a commentary specific to this committee, but it's consistent with a comment I made at a chamber event this morning, is that this is the type of thing that happens when we're moving as fast as we're moving. We've got hearty bills coming to us, 5-6 bills per hearing, and it's enough, and we're getting notice 2, maybe 3 days in advance that these bills are coming. What you're describing is absolutely ideal. And I think we could get to a place where we could have these conversations with the chief author if we didn't have so many bills, and if they weren't being moved so quickly from historical standards through committee, we'd be able to have this time to do our work in a diligent way, and we could have discussions with the chief author and have more friendly amendments and have more amendments worked out in advance. On the second issue with respect to jurisdiction on an effective date, inherent in any kind of bill with an effective date that is in multiple jurisdictions, you're going to have this issue that you've identified. So if we can't make a change to an effective date that is within our jurisdiction but is also in someone else's jurisdiction, we're not going to ever be able to make changes to effective dates, because you don't want a situation where part of the bill is effective on one date and part of the bill is effective on another date. So with all due respect, I think even though that this does have another jurisdictional home, if one of us thinks that the effective date is problematic, I think it is, as long as part of it is within our jurisdiction, part of the effective date, I think it's fair game for us to talk about the merits of that and not rely on a jurisdictional argument that we shouldn't change it. Thank you.
No, Senator Kroon, I will in effect, take judicial notice that this place is crawling with business lobbyists. So I'm sure they've been following this bill, and it's already had a hearing in the Labor Committee, which I'm sure they pay close attention to as well. But be that as it may, is there any further comment or discussion on the A4 amendment? Otherwise, we'll go to a vote. Senator
Mr.
Oumou
Chair.
Verbeten. Senator Howe, Senator Oumou Verbeten wants to add something. I'll give you a chance to wrap up before we take a vote, okay?
Thank you.
Senator Oumou Verbeten.
Thank you, Mr. Chair. And I serve on the Labor Committee, but I just wanted to note that so many of these changes come from the Governor's Committee on the Safety, Health, and Well-being of Agriculture and Food Processing Workers. And there were a number of employer representatives who served on that committee, including folks from the Farm Bureau, Farmers Union, Minnesota Agri-Growth Association, and perhaps, excuse me, just want to refer to our testifier. Ms. Gross, if you have more information about that and could speak to the folks who served on that committee.
Ms. Gross.
Thank you. Yes, that is correct. The Agricultural Worker Wellness Committee does include employer representatives as well, including those from the Minnesota Farm Bureau, Minnesota Farmers Union, and Minnesota Agri-Growth Council. The recommendations that led to this bill were discussed over numerous committee meetings, and there were various opportunities to respond to the recommendations, including a draft email draft form was sent to all of the committee members, and throughout this process, no concerns were raised with the recommendation leading to this legislation.
All right, any other questions or comments, or is there anyone else who intended or wanted to testify on this bill? All right, does Senator Howe, you want to make some final comments on your proposed A4 amendment?
Yes, Mr. Chair, and I'll have note that I think what they failed to mention is the Department of Ag, the Farm Bureau, the Farmers Union, and the Agri-Growth Council were all absent when these changes were adopted. The other concern I have that I think, yes, you have all kinds of labor representatives crawling all over the place. I agree. But you don't have the folks in my neighborhood, the farmers that hire 1 and 2 migrant workers, and they don't have somebody down here crawling all over the place. They have no idea this is going to impact them. And we're going to implement this thing on August 1. I just ask you to take into consideration the small farmers that hire 1 or 2 migrant workers that have no idea this thing is coming to them, to give them a little time. They're law-abiding folks. They aren't hurting these people. And we're going to apply this August 1 and blindside them with implementation without giving them a chance to understand and wrap their arms around this thing. That's all I'm asking. So with that, I ask for your green vote and a support.
Is there any further questions or comments? I mean, I guess I'll agree with Senator Howe in the sense that I don't want to create anything that's going to make it hard for people to adjust before a bill becomes effective. But we're getting conflicting information, I guess, as to whether or not August 1 might be enough time for that to work. So I'd encourage you to continue, depending on how this goes, I'd encourage you to continue conversations with the chief author and with input from other interests to see if there's additional basis for taking action. With that, Senator Howe moves the A4 amendment. All in favor, say aye.
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 Opposed? No. Motion does not prevail. The amendment is not adopted. To the bill, any further questions or comments? Senator Kroon.
Thank you, Mr. Chair. I'm going to offer the, I believe it's the A7 amendment. Yes, the A7 amendment. And I will note for the record that this was not, I don't know what the print date time says, but this was not ready when I looked at this yesterday afternoon, and I saw it for the first time about 20 minutes ago.
The staff is distributing the amendment. And while that's happening, I'll just note, because I know we got some new members of the committee and to the legislature as well. Even if an amendment is given to the members in their packets when a hearing begins, or as soon as it's available, it might give 5 minutes for a chief author or for members to look at it, to understand what it means, and maybe to ask a question or two off the record to get a sense of what the intent is, and maybe go to the person who's anticipating making the amendment to ask a question or two. It might smooth the process along, just so trying to encourage people to be as helpful as we can. And I know this stuff is moving fast, and I've expressed the concern publicly as well about how fast some of these bills are coming through. So I get it. Not everything can be done ahead of time and as quickly as we'd like. But just as a matter of practice, if it's possible, I think it's easier and better practice to do it. Senator Kroon, to your amendment.
Thank you, Mr. Chair. And I'll just note for the record that I came straight from a chamber event this morning, and I literally walked into the room as this was being gavelled in. I would have loved to have had an opportunity to talk to Senator Kunesh about this. I was going to do it yesterday afternoon. By the time I'm sure she probably wasn't even in the office by the time I was getting to this. But in any event, it's a hard thing to talk about over the phone because it's kind of clunky. And I think this should just be a technical amendment because when I read it, this part of the bill, it wasn't making sense to me. So we're starting on lines 5. Page 5, line 6. And this is a recurring problem, so I'll just go through this one. But it currently says the disclosure must be written in English and Spanish or another language if the person's preferred language is not Spanish. I was a little confused by the wording of this. I think the intent was the disclosure must be written in English and Spanish, but that if the person doesn't speak Spanish, it would be English and that other language that they speak. And that's the intent of this amendment, is to make that clear and to clean up the language a little bit. Thank you.
Any suggestions? I think that's fine. I think it's fine. Okay.
Senator Pappas.
Mr. Chairman, I can see where that's confusing. It just kind of depends what the comma means, or if it's understood that it's English and Spanish, and that the English also modifies the another language if a person's preferred language. And I'm not sure who did the original drafting, but maybe we could ask Senate Counsel to clarify. And I think that if it's not clearly understood that way, then Senator Kuhn's amendment makes sense.
Ms. Primo, counsel.
Mr. Chair and members, it seems like it is clarifying language, and I have not had conversations with Senator Kunesh about this and about the intent of the bill, but I think when I initially read the language, it seems like the intent is to be able to provide the document in another language if Spanish is not the language, the main primary language, and it seems like that's what the amendment is trying to clarify.
Senator Kunesh.
So thank you, Mr. Chair, and thank you for all your input. And again, I would have appreciated just, even an email that said, hey, I have this amendment, here's the language, take a look. I was here till at least 7 o'clock last night, so easily would have been able to stop over and chat with me. I understand why this might be needing some clarification. If I'm not mistaken, I would say the largest portion of our migrant workers are Spanish speakers, which is why I think it's probably says English and Spanish, but under the way that you have presented this amendment, I will accept this amendment.
Is there any further discussion on the A7 amendment? Senator Kroon moves the A7 amendment. All in favor, say aye. Aye. Opposed? Motion prevails. The amendment's adopted. Any further discussion on Senate File 61? Senator Kroon.
Thank you, Mr. Chair. I'm going to ask this question because I'm not sure if I'm thinking about this right. I'm going to direct your attention to page 3, starting in 3.5, the civil action that's being added. And my question then also relates to the fine in 3.12 through 3.14. And I note in the civil action, what was interesting about this to me, in the fine section of the 3.12 to 3.14, what was interesting is it says the fine shall be payable to the employee aggrieved. And so the commissioner levies the fine on the employer, but presumably pays that, when it collects the fine, pays it directly to the employee. I'm not sure how common that is in this area. But my question is how that relates to the civil action, because we're creating a fine that the commissioner levies that is payable to the employee, and we're creating private right of action. And I'm struggling with how those two sections work together, because we're talking about damages. Presumably the employee is going to be collecting the fine. Would that reduce their damages under the civil action? Are we concerned about that in the language, or are we just going to leave that up to a judge? How that's going to work. I just wonder if you had any thoughts on that.
Ms. Gross.
Thank you. So to provide a bit of background, the 3 laws that are at issue in this bill, for each of them, DLI could assess fines or penalties, and in each of the 3 cases under this bill, DLI would be able to provide the penalty or the fine that is collected to the worker aggrieved. And so this would be separate from the civil action, so there wouldn't necessarily be a civil action as well as an action by DLI. And DLI also has the ability to determine when they receive a complaint or receive information about noncompliance, whether they would embark on an enforcement action through our compliance action authority, or whether, for example, we would instead provide education and preventative efforts to the employer. So we wouldn't necessarily take action if we were aware of private action already taking place. We are anticipating that oftentimes, because of the type of worker at issue here, migrant workers or those in the meatpacking or poultry processing industries, that they perhaps will not have access to private counsel, and therefore DLI could take action through their enforcement mechanisms to collect fine or penalties on behalf of the worker aggrieved and to provide that to them.
Senator Kroon.
Thank you, Mr. Chair, and thank you for that answer. It does it clears it up a little bit, and I'm not going to offer an amendment on this or spend too much of my mental energy if the employer's not here to lobby for themselves. I'm not sure what I can do with this. And I do have a little bit of concern if there is a civil action, if there is a scenario, and I think it's possible, maybe you're saying it's not likely, but where both of those things happen at the same time, I guess the judge will just have to figure that out when they're calculating actual damages. If the employee has received $1,000 for each violation, that presumably would lessen their actual damages under the private right of action. But again, if the employer's not here, I'm not going to make an amendment or do anything with that. It's just a concern that I saw in reading this. And finally, Mr. Chair, relating back to my previous amendment, I'm wondering, and I just saw this as I'm going through this morning, my apologies, but I don't know if the same amendment should be made on line .2.29 to keep for consistency, or if that is a different part of the section. I'm not sure, but I thought I would raise that for the committee's consideration to see if another amendment should be made on that. Thank you.
Well, Senator Cronin, it looks like on 2.29, the grammar of that sentence is set up differently than the grammar of the sections that you clarified with your earlier amendment. I'm not sure that that kind of clarification is necessary. What do you think?
Thank you, Mr. Chair. And I'm not, and I did notice that it is similar. And so I just wanted to flag that for the committee's consideration. I'm not prepared to include that in the amendment unless other Senate counsel thinks it should be, or the intent of the author. I'm not making an amendment on it. I just wanted to flag it for the committee's consideration. Thank you.
And I'll note, Senator Cronin, in light of your earlier comment, I also made a note with regard to the civil action and the fines that it could theoretically result in double recovery for the worker, the employee, which I'm not a fan of, a double recovery. So they ought to be fully compensated for whatever the losses are, and appropriately so, and that should be it, as far as I'm concerned. And the question is whether or not we leave it up, I think, whether we leave it up to the agency's discretion as to how they proceed, or whether there ought to be some provision for an offset if one or the other is already ordered and transmitted. Might be a little hard to draft that on the fly, but although counsel's pretty good. Ms. Primo has some language for us to consider. If you'd like, Senator Kroon, we can try that. Ms. Primo?
Mr. Chair and members, page 3, line 9, after the period, insert, damages awarded under this subdivision shall be reduced by the amount of any fine paid to the employee under subdivision 6, period. And I can read that again.
Senator Kroon.
Thank you, Mr. Chair. And previously I said I wasn't going to spend the mental energy to come up with an amendment on that, and Senate counsel did that for me, so thank you very much. Spending your mental energy instead of mine. I appreciate that, and perhaps I shouldn't have been so flippant before about the employers not being here. We do want to make good law and to prevent these types of scenarios, and it is our responsibility to look out for these things. So I apologize for my flippant remarks before. I shouldn't have said that. And I think that the sentence that Senate counsel has added to the end of subdivision 5 makes a lot of sense and makes the law better, so I would make that an oral amendment. Thank you.
Senator Kunesh, what does the chief author think about this?
Thank you, Senator Latz. After reviewing that and speaking with my experts here, we will accept that amendment, that verbal amendment. Would you please repeat it for us one more time, though?
Yes, we'll have counsel reread it, and she's also flagged another provision in law where that might also be applicable. That's in the bill. Ms. Primo.
Mr. Chair and members, I'll point you to the other provisions, and and it'll be the same amendment if that's what the motion is. Page 5, line 17 would need the additional language, or the same issue exists there between section 9 and section 10, where there's new language being added to section 10 that the fine shall be payable to the employee aggrieved, and then there's also a civil action for those same violations.
Ms. Primo, do we need to have a reciprocal provision in the other subdivision as well, in the fine subdivision, in the event that they happen chronologically in a different order? If the agency takes action and there's a fine first, then a subsequent civil action could account for that. But if the civil action occurs first and then the agency imposes a fine, there isn't an offset required. At that point, if the civil action's already closed, it's too late to offset.
Mr. Chair, yes. Yes, that's true, that if it went in reverse, the commissioner could issue the fines and there would be nothing to reduce that amount that's recovered. So yes, that problem would exist if the committee seeks to address that. We can come up with language for the fines, the subdivision on fines as well.
Senator Kroon, what do you think about this?
Thank you, Mr. Chair. I think some reciprocating language would be appropriate. Perhaps the reverse isn't quite as big of a concern because the agency would have, presumably would have knowledge of that private right of action that has been concluded and hopefully would take that into account in the decisions to assess the fines. So maybe it's a little bit less of a risk, but I think in terms of being consistent and making sure that's in there, it probably makes sense.
Do you want to speak to that?
Ms. Primo?
Mr. Chair and members, so the additional motion, the additional amendment would be page 3, line 14, before the period, insert, except the amount payable to the employee shall be reduced by any damages awarded under subdivision 5.
And then, Ms. Primo, a comparable amendment on page 5, line 5.21.
Mr. Chair and members, I'll read the 2 additional amendments that would need to be made. The subdivisions are different, so that's what would change. I can't necessarily do it all as with all the pages and lines. So, page 5, line 17, after the period, insert, damages awarded under this subdivision shall be reduced by the amount of any fine paid to the employee under subdivision 4. And then on page 5, line 21, before the period, insert, except the amount payable to the employee shall be reduced by any damages awarded under subdivision 3.
Senator Kunesh.
Mr. Chair, yes, we will accept those amendments.
Senator Kroon.
Thank you, Mr. Chair. I don't think we've officially made the amendment, so I would move to add those 3 additional things that Senate Council just added to my amendment, just so we have it properly before the committee.
Are there any questions, comments, discussion on Senator Kroon's amendment? Does anyone need the amendments to be reread? Then all those, Senator Kroon.
Senator Latz.
I'm sorry, Ms. Gross.
Thank you. I just wanted to mention from an enforcement standpoint by DLI, it sometimes might be difficult for us to know if there has been a private right of action, especially if there was a settlement, perhaps that is not public. I just wanted to, mention that there might be some some complexities in terms of this amendment, but as long as we are able to be aware of the result of the private right of action, then I think we're fine.
I suspect at least one of the parties to any settlement would have an interest in notifying the department, and that would probably be facilitated in a settlement agreement. Any further discussion on Senator Cruin's amendment? All those in favor say aye. Aye. Opposed?
Aye.
All those opposed? Motion prevails. The amendment's adopted. Members, it's just about 11:30, so let me just find out, is there any further discussion or amendments to offer on this bill? Senator Oumou Verbeten.
Thank you, Mr. Chair. I move that Senate File 61 as amended be recommended to pass and re-referred to Finance.
Mr. Chair?
Senator Howe.
You know, Mr. Chair, I probably wouldn't have been, make this amendment to that motion if my amendment would have been added on, but due to the light of the effect on small farmers on this, I would amend that motion to refer it to the Committee on Agriculture to give them a chance to take a look at this and make sure that effective date isn't going to dramatically impact and actually catch people that we don't want to catch. So I would amend that motion to move it, re-refer it to Ag to get them a chance to look at that effective date.
Senator Howe moves to amend Senator Oumou Verbeten's motion to re-refer the bill to the Agriculture Committee instead of the Finance Committee. Senator Kunesh, your position on this proposal?
I would not accept that amendment.
Is there any further discussion on Senator Howe's amendment? All those in favor say aye.
Aye.
Opposed? Those opposed? No. Amendment does not prevail. We're back on Senator Oumou Verbeten's motion to that Senate File 61 as amended be recommended to pass and be re-referred to the Senate Finance Committee. All those in favor say aye. Aye. Opposed?
No.
Motion prevails. Members, we are in recess until 12:30. Enjoy your lunch, and Senator Limmer, please try to eat something between now and then.
Mr. Chairman?
Let's see if we make an adjustment here. If Senator Limmer does not need to be at committee right now, I don't want to deprive members of lunch, including myself, because everyone else can sit at a backbench, but I can't as easily sit back and eat, and we can't all participate easily if we're eating anyway. So,
Senator Latz,
Senator
we do
Kunesh.
have people that traveled a distance for this next bill.
do you know if they're planning to be here at 12:30 or planning to be here or already here or planning to be here at noon?
They are all right here right now. And just FYI, I do have a full afternoon myself.
I understand. I
Yeah.
don't think any of us want to be here any longer than necessary to do the job right today.
Mr. Chair, Senator Eichhorn is on that committee, though.
Oh, that's right.
Oh, Senator Eichhorn. Has Senator Eichhorn already left the hybrid?
I'm sorry, Mr. Chair, are you talking
Senator
about which committee rules?
Apparently, there's a subcommittee of rules that is meeting at 11:30, and it sounds like Senator Eichhorn is on that subcommittee, so is not able to join us
And
right now.
as I just checked my calendar, so am I.
When do you think
My
you can
apologies.
return, Senator
I can be
Kunesh?
back at 12:30. I
All
will
right.
be back at 12:30.
We are in recess until 12:30.
Thank you.